We put on a presentation about 4 years ago, and we we introduced it with the good housekeeping seal of approval, because maintaining a good corporate minute book or an LLC minute book, as is more popular these days, isn't foremost on the minds of most business owners. It is, as it was, very important. My partner Brian Dardis will explain all the reasons why. And 4 years ago, I laid out certain conditions for obtaining from Myers-Roman the good housekeeping seal of approval. This year, the conditions have been narrowed to two. Listen carefully to what Brian has to say. And the second, read carefully I'll call it a seminal work, a short article written all of 2 days ago by me. That's part of your handout materials. Caption, why are corporate minutes so important? It's worthwhile reading, I believe, and I'll share only one story because it's a dry topic, but the story has left its impression with me, and it goes back almost 20 years. There was a dispute between two warring factions of shareholders. There was 50-50 ownership. There was a partially executed buy-sell agreement, no stock certificates, no share ledger, no minutes, no nothing. And then all heck broke loose. And the lawyers came, and one of the lawyers on the other side came with the partially executed stock shareholders agreement and an unexecuted stock certificate, because one of the agreed terms was that if additional capital was provided, whether, regardless of form, additional shares would be issued. But there was no written document, and there certainly were no share certificates. So the attorney, who was not in this room, came with a stock certificate. My former law partner looked at the stock certificate. Interesting. Well, my client owns the company. No, he does not. He does not. It was an unexecuted stock certificate. It looked like this. It was never signed. There was nothing in the share ledger. And the most tangible evidence of ownership that would have supported that client's position was never attended to at the outset. And that is an extreme example, and not an example that Brian's going to reproduce, because it was one of a kind. It was, and I think there's two gentlemen here who know my former partner who ripped up the stock certificate. And it's important. Brian, tell them why.
Good morning, everyone. Thanks, Scott. Can everyone hear me? Okay. I have been given the enviable task of waking each of you up at 8 a.m. on a Thursday with the riveting topic of corporate minutes. So everyone brace yourself. So we're going to have fun. But in all seriousness, I mean, it seems like it's a mundane topic. Keeping accurate and up-to-date minutes is a very important undertaking. And unfortunately, and I think mostly due to its mundane and seemingly mundane and non-urgent nature, it's an undertaking that often gets overlooked and just not done. Failing to keep accurate corporate records and minutes can have serious unintended consequences and effects. I'm going to give you a quick example. I do have some examples, Scott, believe it or not, as to why this matters and why we should care. That doesn't involve a stock certificate. It involves nothing, actually. A number of years ago, at a firm I was with, we were representing a corporation in a lawsuit. This corporation got sued for what I'll call the bad acts of one of its employees. The corporation was in the process of going out of business, but it was generally insolvent. And the plaintiff's counsel wisely and astutely brought the majority shareholder into the lawsuit under a person in the corporate veil theory. Basically, that's a theory that the majority shareholder is an alter ego of the corporation, and any acts of the corporation were the acts of the majority shareholder. It's a way to get after the majority shareholder for the same liability as the corporation would have. Unfortunately, and I should note that we did not represent the company in their transactional work, they didn't have anything. They formed a corporation, and they didn't produce any corporate records, no bylaws, no code of regulations, nothing. And it turned out to be, as discovery was going on, a very big uphill battle. And ultimately, the matter was settled, but it settled semi-favorably, but it could have been much easier to deal with and much less expensive for our client if he was able to produce corporate records to put the alter ego piercing the corporate veil theory to bed quickly. That, like Scott said, that's an extreme example, but it's a real example, and these things do happen. And the point is, a lot of small business owners, they don't want to go through these, the mundane issue of just keeping simple corporate minutes and records, because it's one of these things like, I don't care, why does it matter? And the vast majority of the time, it's probably not going to matter, nothing's going to come up until it does. And when it does, that little bit, that ounce of prevention is worth everything. So these are easy enough things to do. They're things that you should do or required to do, and it just makes life a lot easier and a lot less expensive when problems do arise. And sure enough, they often do. Scott mentioned his handout, why corporate minutes are so important, and I do encourage you all to bring it home and read it. It's really got some good information in there. But just to summarize it, I'm not going to read it for you, but the bottom line is, small business owners form entities, they form corporations and LLCs because these entities infer certain rights create certain rights and benefits for the equity owners. Basically, limited liability for those equity owners, and there's certain tax benefits depending on the type of entity and the type of the business. Simply put, these benefits and these rights can be compromised and even lost if corporate minutes and corporate records are not properly taken and kept. I mentioned in my example of piercing the corporate veil. That's a legal theory under which a claim holder can go after the equity owners as if they were the alter ego of the corporation. That's an actual cause of action under Ohio and other jurisdictions, and it's there, and you can easily protect yourself. A small business can easily protect itself from these claims by just keeping good records. It's as simple as that. It's not that simple, but it's the simplest, best way to do it. And then there's a number of tax benefits that can be lost or compromised, or the burden of proof with the IRS can shift if you don't keep good records. One of the good examples in Scott's memo is the expenses versus dividends. The IRS may disagree with your designation for payouts of employees and shareholders.
Brian, another excuse me, is a loan versus a capital infusion. If there are loans being made, it doesn't take a lot of effort to have those loans properly documented in the ledger and properly evidenced by a promissory note, even if it's a demand note.
Yeah. And then another benefit that is kind of buried in the bottom of this is, keep good records, especially when you have a multi-member LLC or a multi-share corporation. It can really help settle internal disputes that arise later on. When shareholders form a company, everything's good, everyone thinks things are great, but things don't always end up great, and that's when it's good to have good corporate records and buy-sell agreements and operating agreements and whatever else you're going to have. I'm dealing with a company right now. We represent a 50% shareholder, and it's a pretty small company, and these guys him and his partner formed this company about 12 or 13 years ago. They had great intentions because they bought this nice-looking corporate record book that's got all this nice stock paper. However, nobody filled any of it out ever. So it's got a bunch of blank, it's 30 pages of blank, nice stock paper. Well, these guys hate each other now. They're both taking salaries. They both are accusing each other of stealing from the company. There's no agreement whatsoever as to who is entitled to what. And we're relegated to the Ohio Revised Code and case law to settle our dispute. And unfortunately, cooler heads are not prevailing because they both feel wrong. So a little bit of documentation would have helped go a great deal a way to help solve this dispute. So, things don't always work out great. Disputes happen. Records and up-to-date records can help diffuse those situations. So that's, a big part of the why. This is why we look at these things. I mean, it's just good housekeeping. Here, some of the things you're going to want to look at. So the first slide, the first couple slides are what I would call the quote nuts and bolts of business entity records. A corporation or LLC should have an annual meeting, an election of directors and officers or managers for an LLC. keep a share journal. These are actually requirements under the revised code for a corporation. So failing to do that if you have a corporation, you're actually violating the requirements under the law. LLCs, it's optional. It's not a requirement under the law. Your operating agreement may or may not require these things, but for the reasons I discussed, it's a good idea anyway. Share journals, there's a note here, ownership changes. It seems like an obvious statement that you should keep a written record of changes of ownership of an entity. And it is an obvious statement, but it doesn't always happen. I've dealt a number of occasions where, for example, I was handed a corporate record book once by a client who had become a pretty good client, and I glanced through it and I noticed there was a minority owner that owned about 10% of the company. And I said, well, guys, who's this? And they said, oh, yeah, we forgot about him. I said, well, when's the last time you communicated with him? I don't think anyone's talked to him in about 10 years. I said, so he hasn't gotten a notice of any, he's gotten no tax returns, no notice of any meetings, nothing from the corporation, nothing from the corporation in over 10 years. I said, yeah, he doesn't really own anything. He's just a little, minority member or minority owner. And I said, oh, fortunately, we were able to deal with that, and he could have ransomed us, and he very well could have sued us if he sued my company, my client, if he chose to. It worked out well, but it could have been disastrous.
Brian, could I interject for one moment? A lot of times, and lawyers are as guilty of this as many others, when an operating agreement provides for membership interest or membership units, we don't go the extra step to issue LLC unit certificates. Sometimes banks will insist on it, but even when banks don't insist on it to evidence a pledge of interest, it's not a bad idea to have a minute book for an LLC. As Brian said, it's not required, but it's good practice, and we're training clients to adopt that practice.
Thanks, Scott. Another note on here in this slide is qualification to do business in foreign states. A business entity that operates or does any, I'll call it material business for lack of legalese, in other states is required to register in those states, usually with the Secretary of State. In addition to the initial filing, there are, every state has different filing requirements, and failure to comply with those can lead to cancellation or penalties or other things depending on the state. Cancellation can have some unintended consequences as well, anything from fines to potential liability for individuals. There's even, I think, one or two states that provide that contracts are set aside if the corporation or LLC was not in good standing. So, easy thing to monitor. You file, you docket it, and you just keep track of it every year, but important to do. Ratification, this is also part of the quote nuts and bolts. Ratification is simply the corporation or the LLC adopting the actions of its officers or employees or adopting contracts entered into by the officers or employees, ratifying that it was indeed the corporation's intent. Oftentimes for bigger deals it's done as the deals are completed, but it's a good idea just for the directors or the shareholders or the members just to ratify all the contracts entered into in any given year, just to clean house and just to make sure everything's clean. Some potential possible consequences. Contracts it could be argued that a contract should be set aside because it was never properly ratified. That could lead to potential arguments for individual liability on those officers or employees that executed those documents. Are these scenarios a little bit far-fetched? Usually, probably yes, but why create an arrow for an adverse party to put in their quiver when an argument comes? It's just not. It's an easy enough fix, and you take care of it, and it's done. Also, there's we talked a little bit about tax ramifications. Provide some evidence to go to when the IRS comes at you and challenges what a dividend was or something like that. You have some evidence that, listen, we talked about this. It's in our minutes. We adopted it. Borrowings. Scott mentioned this. I was going to mention it. It's always a good idea to document any type of indebtedness, particularly amongst shareholders or affiliates of an entity when there's not going to be a formal promissory note, maybe from a bank. It's just when disputes happen later, or when the IRS comes calling, you have that documentation and it's there, and you can show what happened. This is a little more on gratification. This is a lot we talked about with the tax consequences. Dividends, distributions, employee bonuses. It's a good idea to document these just to avoid any unintended tax consequences. Shareholder agreements and LLC agreements, or operating agreements. Oftentimes, when we draft a buy-sell or an operating agreement, we will have buyout provisions upon a triggering event such as a death or a disability of a shareholder or a member. Frankly, the best way to handle this is for all the shareholders to agree upon a value and attach that as an exhibit to the agreement. That value, assuming you can do this, what we generally like to do, and the best practice is to put some kind of a expiration date of that value. So that value becomes stale if it's not agreed upon by that. For example, that value is good for 2 years. If it's not, if the triggering event should happen 2 years or after, that value would be stale, and there'd be a complex, convoluted formula to determine the value. We try to avoid complex, convoluted formulas when we can, so it's just good practice to meet, talk about what the value is, and update it on an annual basis, just to make sure it's attached.
However, if the shareholders have decided for whatever reason to use a formula approach, that formula needs to be looked at because it may be based on economic conditions that existed when the contract was executed. Those conditions no longer work. The industry has changed, and most importantly, if the funding is no longer there and it becomes a balance sheet funded buyout, that's something that the principals need to be addressing in advance. And if they don't address it, likely their secured lender will force them to address it.
Thanks, Guy. So we're slightly switching gears here from, we were talking about the good housekeeping, the more affirmative actions and meetings. This is more, reviewing key documents, really for the purpose of identifying dates and deadlines and other, things to be aware of. So that's the next few slides are about some of the key agreements and documents a small company should be reviewing. The whole goal for all this is to avoid surprises. You don't want a deadline to come and go that you didn't realize was coming and going, and lose a lease right or an option right or something similar to that as a result of simply failing to take a look at your deadlines and your documents. Loan documents are obviously some of the small business's key documents. Covenant compliance. Every loan document I've ever been involved in has financial reporting requirements, and they usually require a company to submit the company's financials to the bank within a certain number of days, whether it be 90 or 120 or 60 after the end of a calendar year. Assuming the company keeps the calendar year. You want to know what those are. You want to know what has to be delivered, and you want to make sure you deliver what's required. Failing to do that is a breach of your loan documents. There's also another, most commercial loans, whether it be a real estate loan or a line of credit, have performance covenants. Whether it be a debt service or borrowing base or whatever. It's a good idea to review your numbers and kind of see where you're going to fall if you can. Because the key, we represent a lot of banks, and I can tell you, banks don't like surprises. It's good to know where you're at. It's good to communicate with your bank and take a assertive, proactive approach. Financial reporting, a small business, this is, they're probably I would hope they're keeping financials and doing pro forma projections, so clearly that's something that should be done anyway. UCC continuation statements is on here. If a company's a secured party under a UCC, that does have an expiration of 5 years. If you don't pay attention to that and file a continuation within that 5 years, you lose your priority rights, and your secured interest can be primed by anyone else that would file in the interim. And this isn't on the slide, but I'd mention, if you have judgment liens or mechanics liens or any other types of liens, these usually have expiration dates as well. So good idea to docket it, have your law firm docket it, pay attention to these dates, and figure out a course of action if and when this expiration comes for any type of lien or security interest. Another key document to review are leases. Leases usually, especially real estate leases, usually have a lot of key dates that are very time sensitive. For example, you may have an option to renew, you may have an option to terminate, you may have some renewal rights. These usually come with some certain date, whereas you have to, a tenant, as I'm referring to tenants for the most part, has to submit some kind of a written notice either to exercise its rights or to not be stuck with an additional term. So, for example, a common lease term would require a tenant to exercise 90 days prior written notice prior to the expiration of the current term in order to exercise a renewal right. Could be vice versa. Could be if they don't submit written notice of his intention to terminate by that 90-day period, they could be stuck in for an extended term. So it's not hard to do, and it's important concept to keep in front of you is the time-sensitive deadlines under leases. CAM expenses, for any of you that don't know, is common area maintenance expenses. This is additional rent under a lease. Oftentimes, a lease for a multi-tenant building will have CAM expenses, but a tenant will have a right to audit those expenses and challenge them. These almost always have time-sensitive deadlines with very detailed requirements on how you can and cannot do it. It's important to note these deadlines because you lose your rights if you don't exercise them. Insurance certificates, my last point is oftentimes under a lease, and your loan documents for that matter, you're going to be required to provide evidence of insurance to your lender or your landlord. You may have an affirmative obligation to provide updated certificates in your documents without notice from the landlord or lender, and could be a violation of the terms of your agreement if you don't do that. So just a good thing to note to pay attention to. Do we need to provide updated insurance certificates? Once again, not a difficult thing to do, but you could be in violation of your documents if you don't do it. I think, Scott, were you going to talk about employment agreements?
You said it was boring. I think it's fascinating. I don't know whether anyone else in the room thinks it's interesting, but I think it's fascinating.
Good minds think alike.
I'm going to skate, I'm trying to think of a male skater. I'm going to skate Brian Boitano-like through the rest of my, there's got to be more current skaters, through my outline. Employment agreements. Many employment contracts are tied to the calendar year. And now is the time, actually last month or the month of October was the time to look at the date that's necessary in order to provide notice and avoid an automatic renewal. If you have an employee that you'd rather not keep, the time for opting out, of the evergreen clause is now or 2 months ago, perhaps. Same is true for vesting. A lot of times vesting schedules are tied to a calendar year end. And sometimes those vesting rights can end even if a termination is without cause. So if you're at risk of being saddled with paying some phantom equity or granting additional shares pursuant to a vesting schedule to an employee who you don't think is part of your long-term future, now is the time. Salary review historically is done at the end of the contract year, again coinciding with the calendar year. Bonus calculations also are done. At this time of year, typically they're done with the bonus paid within 60 days or 90 days of contract year end. If a preliminary calculation shows that a substantial bonus is due, and you know that you're not going to have the cash to honor that obligation, now is the time to perhaps negotiate those terms. Computer software agreements, license agreements, maintenance and support agreements, website hosting agreements. The scope of services may change over time. If there are upgrades built in that you don't need, now's the time to address those. If there's a stale fee schedule and that a contract has gone on for years and years, and this is really something for the provider of the services to be attuned to, but it goes both ways. If there is a reduction in scope of services and the fee schedule remains as it has been for the past 5 years, it needs to be looked at and amended. Purchase and sales orders is something that Ron Friedberg will be speaking about later. I only wanted to point out something that I don't think is covered in Ron's outline, but will be the subject of a client alert early next year. It's the inadvertent contract through exchange of emails. There are some recent cases that are sort of scary. Most of them are in the residential real estate context where there are email exchanges going back and forth. Yes, I'll sell you the house for $50,000. No, it's $50,001. Okay, but there'll be some supplemental terms and conditions. I'll send you the addendum. Courts have ruled that the agreement was made through the exchange of emails, and that the addendum was a proposed amendment to it. But the kernel of the deal, the contractual obligation arose merely from the exchange of that email. We have been encouraging some of our clients to adopt disclaimers, saying that any email correspondence does not give rise to a binding and enforceable contract. And if you'd like for us to work with you in developing a disclaimer, either for you or for clients of yours, we'd be glad to do so. The intellectual property, looking at the website, the terms of service, again, needs to be freshened up. I'm not sure that people are carefully studying privacy policies anymore, but it's important to police that, and there should be a point person, for that. Looking at your intellectual property portfolio, taking stock of it, looking at your trademarks and copyright. Is everything still registered? Does something require renewal? Are you using the trademark designation that you paid handsomely for? This is something that a lot of clients forget about. You go back and forth with the trademark office with office actions that go 6 months, and you've paid the attorneys who knows how much money, and then you don't put the R, the circle R. That's what you paid for. That gives you valuable rights outside the scope of this seminar. But it's a good time to remind yourself of that. Similarly, if you've got casual independent contractors doing creative work for you, and you don't have a work for hire letter or a clause in your contract that says that this is the work of your company and that the author is surrendering ownership of it, the law states, copyright law states, that it belongs to the creator. So we encourage our clients to look at those contracts to make sure that there is a work for hire clause in each of those contracts. The domain name portfolio, these two need to be monitored, updated, make sure that there's current registration. Are any names expiring? Are there any parties in your website? Take a look at your website. If you've got people in your website, photos, and they're no longer there, or there's reference to them, it's awfully embarrassing. We've encountered that ourselves. No longer. We wind up using headshots of people, and oh boy, that person lost a lot of weight. We don't want to.
I was
Eric,
6'5" in one version.
Yes, you were 6'5" and 260 pounds. Eric, we don't want to do that again. The record retentions policy, and Peter Turner mentioned at the very outset that this is very important. The benefits of compliance with a good record retention policy are lost if compliance is intermittent or if compliance is non-existent. You're sometimes better off not even having one if you're going to ignore what you put in place. But what is put in place typically covers three categories: the so-called must-keeps, the want-to-keep, and the destroy or delete. The must-keep is driven in part by the need to comply with federal and state regulations. There could be industry-specific regulation. The one that jumps out at me right now is transportation, but there are so many others. There are requirements for maintenance of employment records that Seth can talk about at a later time, because we are being pressed for time. Of course, there are taxes, and the holding period for that ranges from 3 to 7 years. The most important component of it from a litigator's perspective is the so-called litigation hold. It does no good to adopt a record retention policy when litigation is pending or litigation is imminent. You need to have that policy in place well in advance. And there are federal regulations governing the litigation hold, federal rules of evidence, and they are being adopted. I'm not the litigator on the panel, but they are being adopted in substantial part by the courts in this state. You need to establish clear procedures for compliance and enforcement with the record retention policy that you do adopt. Now's a good time for a short plug. We have had occasion in the past couple of months to prepare record retention policy for clients in the manufacturing and service sectors. It's not a one-size-fits-all. You know, in the manufacturing sector, evidence of quality of goods certification becomes very important, and those should be held on to for a long, long time, because you never know when a product field failure will occur. It's not a good idea to save everything. That's not cost effective. It's not serving any legal, business, or administrative purpose, and it could, in the case of litigation, add to your burden, where you'll be digging and digging, and there's no cutoff to the records. Not one of us on the panel is a certified specialist in taxation. We did have Mario Fazio with us earlier this morning, but he had to leave, presumably to attend to pressing year-end tax planning matters. But he did prepare, and it's included in your materials, a very helpful short article captioned Year-End Planning for Businesses. Some of you may have already received it. If you haven't, you will electronically. You have it here. I wish to point out only the bonus depreciation for capital purchases in 2013. This is on page 2 of the short article captioned Year-End Planning for Businesses. The deductibility of certain qualified leasehold improvements. It's never too late in the year to establish a DISC, a domestic international sales corporation. We formed one last year at this time for a manufacturing client, and it resulted in savings of over $30,000. So the few $1,000s spent with us to form that entity were well worth it. Deducting losses by members of LLCs to avoid the passive activity loss rules under certain circumstances. This is something that if you or a client of yours is primarily a passive investor but had some meaningful input, there may be an opportunity to avoid the passive activity loss rules. And our estate planning department is not represented in on this panel, but it's always the right time of year to think about annual gift planning. There are 2 other tax pieces included in your handouts. Both of them were adapted from something provided by Bloomberg News Service. They're excellent, and I would commend them to you at your leisure. Finally, the insurance audit. You should be speaking once a year, and now's a great time of year to do it if you haven't already, with your risk management personnel. If you outsource that and you have an insurance agent that you rely on for that, those are some of the things that you should be looking at each and every year. Not listed there are accounts receivable insurance, which is akin to a factoring arrangement in some cases, but it's something that's become attractive, and environmental insurance, which is cheaper than it used to be with far fewer holes. And with that, I'm going to turn it over to Ron.